Hi, I am the 3D printing lawyer. We're going to watch a part of Andrew Martin's video, and then I'm going to cover the theory of copyright law. This is not legal advice. Apparently, Mr. Martin also has this video on TikTok and registered it with one of YouTube's copyright content ID partners. So I've had to blur the video and replace the audio with a computer reading the transcript.
My artwork and sold it in their parks. A long-awaited update. It's been over 2 years since my last update on Disney stealing my work. This is going to be a long one. For those of you who haven't seen my previous videos, here is the rundown. In February of 2022, I was made aware that a fan art model that I sculpted back in 2018.
Now, I've always thought of the term fan art as using a copyrighted character, but in a new composition. Mr. Martin seems to use the word to mean a work that's not authorized by the copyright owner, although later he discusses the copyright of the character and not the composition, so I don't know. Let's keep watching.
Of the tiki drummer from Disney's Enchanted Tiki Room was used by Disney to make a music box celebrating Disney World's 50th anniversary. The artist credited on the music box was Costa Alavezos, who at the time was, but is no longer, more on that later, a product design manager for Disney, and had been employed by the company for over 25 years. But he is not the artist. He is a thief that stole my work and passed it off as his own. Costa could have sculpted one himself or used a scan of the original. That would have been just fine, but that's not what he did. He decided to steal my model, my exact model, down to every scratch, bump, and minute detail. Well, except for my name, which was removed from the bottom. I found out it was removed when I bought one off eBay from a scalper and checked for myself. The process was a little destructive, but I think it was $230 well spent. Since then, I've also purchased a 3D scanner. Sadly, the statue was no longer in one piece, but I was able to scan the bits and put it back together. Here you can see the scanned 3D model. It's a little bit rough, but I think it captures enough detail, and here's my original model. Scan model, and then my model, the scan, and then mine. Can really see that there's no difference between them because they are both my model, the one I made, and the one that Disney stole from me. A common misconception I've seen over and over again the last few years in my comments section is that Disney owns all fan artwork made of their characters. No, they don't. I'm not a lawyer, and American copyright is overly complicated, but here is my understanding. In short, intellectual property owners do not own the copyright of fan artwork of their characters. Fan art and any derivative works have their own copyright separate from the copyright to the original IP. The creator of that fan art owns the copyright to that fan art. If an IP holder has an issue with fan art being made, they can send a cease and desist. And if that fails, they can bring legal action against that artist. But they cannot claim ownership of the fan art. Fan art belongs to the artist that made it. It doesn't matter who owns the copyright of that character. So how did Disney get my model? I put it up for free to download on Thingiverse in 2019 under a Creative Commons attribution and non-commercial license. That means that I allow people to freely download and use my model for personal use, but they must give me credit for that model and it cannot be sold for commercial purposes, neither of which was done by Disney.
All right, so there's a lot to unpack here, and I don't know if it's ironic that he follows other people's misconceptions, which he is correct about being incorrect, but he follows them with his own misconceptions. Let's get the character copyright out of the way first, because frankly, I don't think it's relevant. In general, the character, as well as the sculpture of the character, could be protected in separate ways. But I'm going to pretend that this isn't a copyrightable character because, as I said, it's not relevant. Mr. Martin mentions the simulated scratches, bumps, and small details in the sculpture and how Disney copied them from him. Mr. Martin, though, also appears to have copied the cracks in the wood from the original sculpture. I'll show you here. So the most prominent cracks and that you would probably copy if you're trying to do a reproduction is the one in the face right here. It's in the original. This one right here, which is right here, even the V-shaped one seems to have been copied. And the one behind the shoulder, the one in the face of the drum. So Mr. Martin's copying of these cracks verbatim seems like evidence to me of Mr. Martin attempting to make an exact reproduction of the original sculpture, and not of him trying to do his own take on it. By the way, the arrangement of these cracks is not copyrightable, but I can see how they are evidence of verbatim copying of the overall sculpture. Now let's talk about derivative works. What Mr. Martin did is clearly derivative of the original sculpture. And when making a derivative work under copyright law, the creator of the derivative work typically does own the incremental contribution, not the underlying work. However, not all derivative work meets the legal definition of a copyrightable derivative work. Mr. Martin would have had to transform the original work in a creative way, which he didn't. But most importantly, a derivative work is only created with the permission of the original rights owner. Copyright protection does not extend to any part of a work that has been unlawfully copied. By the way, this means that most copyrightable derivative work is made from works in the public domain, because who gives permission? Now, even if Mr. Martin had permission, not all decision-making is creative, which would lead to an incremental contribution. As I said before, Mr. Martin does not appear to have been attempting to leave his mark, but rather his goal seemed to be a faithful translation of the work into a different medium. Mr. Martin did put in effort, but effort is not copyrightable. Technically, a reproduction, although derivative, is not a protectable derivative work under copyright law. If Martin did not make a copyrightable work, he was not authorized to grant the rights to the reproduction under a Creative Commons license. In fact, Mr. Martin would not even be protected against verbatim copying of the STL file, although Disney would be. So I know what you're thinking. Shouldn't Mr. Martin be able to sue to be compensated for his work? No, because copyright law preempts any state law claims for conversion or quantum merit. What might be confusing then is if Mr. Martin doesn't have a valid copyright, but certainly copyright law doesn't apply in order to preempt state law, right? Wrong. The law does apply because Mr. Martin's model is still a work within the subject matter of copyright, and his claim would be based on unauthorized use of the work. Now, Mr. Martin had said that Disney should send a cease and desist and then sue, not take his work for their own use. Mr. Martin appears to be a Canadian citizen. The way that he pronounced the word process, maybe look that up and confirm. So we've been talking about U.S. copyright law, but U.S. copyright law would only affect Mr. Martin where he committed acts in the U.S. Under U.S. law, by publishing the infringing material of the U.S. entity on a U.S. website, Mr. Martin would be prone to the jurisdiction of a U.S. court. Disney would probably use a DMCA takedown notice on the U.S. hosted content and then sue. There probably would not be a cease and desist. Now, to wrap this up, I think that what Disney allegedly did, and especially what this costed person allegedly did, is crappy. Unfortunately, or fortunately, U.S. law doesn't protect infringers. Mr. Martin's translation of Disney's sculpture into a 3D model does not technically belong to Disney, and they have no rights to possess it, only to control its dissemination. Courts, in fact, have rarely granted the possession of infringing materials to rights owners other than for the purpose of destruction. Disney had no rights to use the infringing work, only the right to prevent its use. No one's copyrights were violated, though. In effect, No one had the right to stop Disney from doing it. Got questions? Drop them in the comments below. Please like this video. Thank you for subscribing. Have a good day.